Saw the 5-judge constitutional bench judgment on arbitration that has just come. And it talked about modification of awards.
Yeah.
Although what I've come to understand is that law almost same ही है, but हल्का कुछ उसमें change किया गया है, because of which it became very hot in the arbitration community.
Yeah.
So I wanted a bite on that, and if we have any stemming questions from them, we can also cover that.
You mean some of the audience is also going to participate?
No, sir. Abhi it's just you and me. I'm gonna be. This is already on record. I'm
Okay,
recording
fine.
this.
Now you're recording it. Then you put it up, and then maybe if questions come.
If I have any question, I'll ask right now. If otherwise people have any question, I'll trouble you again. We'll connect again.
Oh, sure, not an issue.
Ji, sir. So let's just start over the judgment. What was the position before? What is the position now? We'll take only 4 to 5 minutes maximum dead stop to explain what has happened now.
Yeah. Okay.
We can start, sir.
Yeah. Good morning. It's good to be here with you on this group. The question posed is also very interesting, a topic of very high interest to practicing lawyers, particularly in the field of arbitration. As you all know, arbitration is being encouraged at the state and the central level. Private participants are also adopting arbitration as a means of settling their disputes. One of the major reasons why particularly the foreigners are not a little skeptical about doing business in India is about the delay in the disposal of these matters, particularly commercial disputes, which are taking a long time to dispose. In that scenario, one of the questions that has been troubling our Indian courts is whether the Indian courts have the power to modify an award. Now, this has led to a number of conflicting judgments, and ultimately a reference was made to the bench, which is now the subject matter of our discussion. The very question that was posed to the court in the reference is in paragraph 3. It starts with, the very question was whether the power of a court under 34 of the Act would include the power to modify an award. Now, in the reference itself, question number 3 starts with the query whether there is a power to modify an award that is available under section 34 of the Arbitration Act. In fact, the bench, which are 4 of the, except for Mr. Justice Vishwanathan, the rest of them felt that there was a limited power available, and that is the subject matter of our difference. In fact, the majority opinion notices very clearly in paragraph 16 itself that the Act does not give the power to modify an award. Unlike the previous Act, that is the 1940 Act, which had a distinct provision by which a court could modify an award, this Act did not have the provision. Yet, they went on analyzing the contents of the Act, and ultimately, according to me, this is my opinion, I'm not, since it's a forum for discussion. In paragraph 16, one of the major factors, according to me, weighed with the bench was the cost effectiveness of arbitration, and arbitration being a quick alternative relief for resolution of disputes. The bench felt in paragraph 14 and in 40 and 41, particularly if you notice, they would say the power to deny the power to modify an award will cause hardship, will escalate the costs, and lead to delay in disposal. This is a factor which, in my view, weighed very heavily with this bench. Because they feel that ultimately, if a man or a party comes all the way to the Supreme Court, if the award is set aside, he will have to go back to square one or a de novo start of the arbitration right from the beginning again. I think this was a factor among the other things which weighed very heavily with this bench. And therefore, they said the delay in disposal, arbitration being an alternative remedy, etc., will be lost if the power to modify is not actually read into the larger power available to modify an award. This is what, in my view, tilted the scale in favor of this opinion. The second part of it, however, is a little more troublesome. In paragraph 49, when they were defining what was the power, they said, we have the power to rectify computational, clerical, typographical errors as well as other manifest errors, provided it does not include a merit-based evaluation. Typographical errors are clear, clerical errors are clear, computational errors are clear. If 2 plus 2 is given as 3 by the arbitrator, to say that the Supreme Court doesn't have the power to correct it, or any other court for that matter, is wrong. But the potential minefield that is left open here is these other manifest errors which are visible. Now, this has not been defined. The lack of a definition, in my opinion, can lead to certain amount of judicial uncertainty. Computational errors are clear, typographical errors are clear, calculation errors are clear. These are all understandable. But other such manifest errors is what is included in paragraph 49. Does a manifest error include the failure to apply a leading judgment of the Supreme Court? The failure to follow the law of the land? That is a manifest error. You are bound to decide a dispute according to the law of the land. If you don't do it, it is visible, patent, on the face. Still, and to say that is a ground to modify and not a ground to set aside can, in my opinion, in the future, lead to difficulty. They also went on to hold that there are certain powers which are inherent in a court. And this, one of these inherent powers is the power to correct an award. But however, in the conclusion, while they were dealing with, in paragraph 54, they say inadvertent errors, including typographical and clerical errors, can be modified under 34. Similarly, when it comes to interest also, they have felt that there is a power available to modify. In this area, I don't really have any doubt, because if the rest of the award is otherwise found to be good in accordance with law, to deny the power to correct an error, which is available on just on the question of interest, may again lead to a de novo inquiry, etc. But there also, I would agree with the minority view. We'll come to that a little later, where, one of the factors that has, as I said earlier, even for interest, was that the power to correct this is arising out of post-award delays. The obstructionist tactics of a judgment debtor, the obstructionist tactics or the delaying tactics of a lawyer, of a client who has lost the case. They say in these circumstances, we can enhance the interest, we can modify the interest. But the question that comes to my mind is whether the mere delay in disposal of a case can be a ground to modify a judgment or a decree. This is something that should have been kept in mind. Yes, decree holders versus judgment debtors, there is always this ever-going conflict, a lot of case law. Judgment debtors would try to save their case to the best of their possible. Just because there is some delay in the post-award stage, can the award be modified, is the issue which I think was not properly answered according to me. I think here also the factor of hardship and delay weighed with the bench. Again, they went into Article 142 and the power of the Supreme Court to do complete justice between the parties. There is no dispute about that. It is the Supreme Court of India, ultimately. That is the final court. So they have the power to do complete justice. But the question is, what will happen when the other courts are interpreting it? Which courts do not have this power of 142, which is given only to the Supreme Court of India? But one silver lining I could find is in the conclusion, the manifest errors which the Supreme Court held could be corrected is not mentioned in the concluding portion, particularly in paragraph 85. Let us see what this will lead to. And this is the reason why I said I would prefer, personally, that's my opinion, since it's a forum for discussion. My opinion would be, I would prefer the dissenting opinion of Justice Vishwanathan, and I would say that is laying down the correct law. As you know, a dissent in the last court is an appeal to the wisdom of the future generations. And it is hope that somebody would look into it, in my opinion, and maybe take a relook at this entire issue. If you look at Justice Vishwanathan's dissenting opinion, in my opinion, it starts correctly. It notices section 15 and 16 of the 1940 Act. It notices that there was a power given to the court to modify an award. And then it goes into the language used of section 34, and also the interpretation of the Honorable Supreme Court in the 7-judge bench in the interplay of Stamp Act judgment. and states that judicial interference is to be at a bare minimum and to the extent provided under the Act. This is if you start with Section 5 and go up to the end up to 34, you will realize that judicial interference has been kept at the minimum by the legislature. And Justice Viswanathan also notices the clear language used in Section 34 when he says the award can be set aside only if the following conditions are satisfied. This is the plain language interpretation, which is the fundamental interpretation of a statute. He says the statute clearly says the award can be set aside only if. Therefore, it prescribes the points which a court can rely upon to set aside an award. You can't read anything more into it. What is there is clear. What is there is visible. What is there is capable of a very clear meaning. There is no ambiguity leading to the need for a further modification of the language used by judicial interpretation. He also makes a very pertinent observation. In the 1940 Act, there was a power to modify the award. Later, the Viswanathan Committee went into the working of the new 1996 Act, and they recommended that a similar provision should be included in the new Act also. This is in paragraph 94 and 96 of this judgment. But he states, despite 3 amendments in 2015, 19, and 21, this power to modify an award has not been included by an amendment into the Act. Therefore, he says, the legislature in its wisdom decided not to confer the power on a court to modify an award, and a court by a process of judicial interpretation cannot confer upon itself a power which the legislature deliberately did not give it. This, in my view, is a very, very important thing. 3 times the Act was amended after it came into being. 1996 was the Act, 2015, 19, and 21. Yet a recommendation has not been made for modification. The learned judge also rejected the power of inherent power and implied power. Now, inherent power can only be for the purpose of and in aid of the existing power. It can't be for promulgating or for advocating something altogether new, and he has cited the relevant case law on the subject also. But as far as computational and clerical errors, he also agrees, yes, the power should be given to the court to correct it. Because this is the court of the last resort. This is Article 142 that they are using. But here also he sounds a note of caution and says under limited circumstances without modifying the original. One other issue you would find, therefore, in my opinion, my personal opinion, of course, it's the decision of the bench, which I'm bound to follow as a lawyer, all of us are bound to follow. But if you ask me my personal opinion, I would still go by the dissenting opinion of Justice Viswanathan, which, in my opinion, expresses the correct view. There is also a slight reference to the guidelines laid down in the Vishaka case. Most of us know that Vishaka was a case of sexual exploitation, etc., of women in workplace. Because there was absolutely no act, no guidelines, at that stage, the Supreme Court had to step in and filling this huge legal gap which existed. But here we are dealing with an enactment which is there on the statute book, which has been interpreted more than once, in more than one way. Therefore, comparing this situation to the Vishaka situation is not really correct. Therefore, in my opinion, I still feel that the courts do not have a power to review or modify an award, and the majority opinion needs a relook. And in my humble opinion, without meaning any disrespect to the learned judges, Justice Viswanathan's opinion is a better opinion in the circumstances.
Sir, very smoothly squared off and very slick.
Thank you.
Now, sir, आप बहुत अनुभवी जज भी रहे हैं. Now you're practicing also. So what I want to know from you for the young practitioners is that अब इस चीज से प्रोसीजर में क्या चेंज आने वाला है? What is the practical change in the scenario? What should the practitioners be ready for? What is going to change for them?
The practitioners can, as of now, argue that there is a power to modify an award. But you will have to look into the the power. They say it is computational, typographical, or such other errors. And manifest errors, which is not really described. So there is a little scope available for correcting computational, clerical, or typographical errors only. The question that still begs for an answer is, I think some youngster should make it a point and argue it and get an order and come all the way to the Supreme Court to settle it. What are these manifest errors? See, the power of a Supreme Court to correct an award when it is the court of the last resort cannot be compared to the power of a district judge under 34. Any district judge dealing with an application on the 34, if it's Dehradun or the original side of the other high courts, would be a little skeptical in modifying. But I think you should try and advocate and argue for a modification. Because manifest errors, in my opinion, provided they don't go into merit-based evaluation, which means manifest error. This is the judgment of the Supreme Court, which the arbitrator did not follow. Is a way out to a younger advocate arguing this matter. That manifest error is described in paragraph 49, which you can use and argue and say this is a manifest error visible ex specie from the record. It is manifest and clear to the naked eye. Therefore, you can correct the award. But you should always remember correcting the award means separating a part of the award which is severable. But if the whole award is intrinsically linked, you cannot use this power. If the award is severable, there is a part which can be separated. You can definitely argue that the power to modify an award is there. You don't have to set it aside and send us back to square one again. Please retain the rest of the award, change this part of it.
Sir, as far as I am concerned, as a young lawyer, I already have an authority sitting across the screen for me. So I would like to ask you, what do you think should be included in manifest errors or the word manifest?
See, you go by the plain grammatical meaning. Manifest error is something that is clearly visible. It is manifest. It is clear.
What could be the heads? What could be the heads? Ki ye cheezein isme aa sakti hai.
See, I also mentioned it. This is the slight minefield is the word I use. See, anything, an error of law.
Judgment.
Yes. Ignoring a vital admission made by a witness in the course of the arbitration is a manifest error. But then these are all grounds which you find under 34 to set aside an award as per the case law that has been evolving. That has been brought into the modification. You should try. I think in view of this, I mean, you're dealing with a very experienced bench. Apart from my personal opinion, they have deliberately chosen these words and have included them. First, they said clerical, computational, typographical errors or other manifest errors, provided it doesn't need a merit-based evaluation. That means you don't have to go in deep into the pleadings, into the evidence, and then say, evaluate it, therefore this is wrong. This should be an error which is visible, ex facie, patently visible on the face of the record. Then say, this is an error, obvious. This is the section which was overlooked. This is the case law which has been overlooked. This is the admission of the witness which has been overlooked. Or this is the document which the party has signed and it is overlooked by the arbiter. These sort of things can be brought into that manifest error.
Right, sir. But truly, I think it's open to exploration and it is vulnerable. As far as the lawyers are concerned, they're going to use it as a very expansive and a very vague term. And they're going to get all of it injected in their pleadings before the court.
That's how, I mean, that is also necessary for the law to grow and the law to be solidified. So let us see. But yes, there is this area which can be used and which I'm sure will be used.
So we can say we are waiting for a new judgment very soon on this point.
I think so. I hope so. And I hope it is clarified. I may be wrong also, but you never know.
Right. Sir, so basically arbitration jab ho jati hai, we are done with an arbitration, the award, we are in the court or we are, challenging it. We go back to the same arbitrators or there's something else? Yeah. What's the procedure?
That also, in fact, if you read the judgment very carefully, that is there. If the same arbitrators are there, yeah. But if normally you can ask for a fresh appointment since somebody has already expressed their opinion. That is also discussed in the scope of this judgment. But if you feel that the arbitrator has already expressed, I would still feel you should ask for a fresh tribunal to decide de novo.
Okay. No, because I am a novice in arbitration. I've had only one matter. I went in for Section 9 interim, and that got dismissed. So I never got the chance to enter into an arbitration. So I
Even in
wanted to
this
know what
judgment.
the procedure is.
No, that is, in fact, that is also dealt with. The question of limitation was also dealt with in this judgment. What happens to the time spent? All of this was discussed. And you will find that, for correction, even under the current act, if under 34, if there is a ground which the court finds, which is where the award can be set aside, the court is still given the power to send it back to the arbitrator to correct that error, so that the reason for setting aside the award is removed. That you will find in the section itself. I'll just read it out to you since you raised the question. That is discussed in this judgment also. (33) of the Act deals with correction of certain errors in correction and interpretation of the award and additional award. Within 30 days from the receipt of the award, a party with notice to the other party may request the arbitral tribunal to correct any typographical errors or similar errors of a similar nature. A party with notice to the other party may request the arbitral tribunal to give an interpretation on a specific point or a part of the award. And then the court can make an additional award. And then also in 34(4), you will see that on receipt of an application, the court may adjourn the proceedings to a period of time determined by it in order to give the arbitral tribunal an opportunity to resume the arbitral proceeding or take such other action in the opinion of the tribunal, which will eliminate the ground for setting aside the award. If there is an error or which there is some amount of ambiguity, there is no clarity, instead of setting aside the whole thing and going back to square one, the Act itself gives the under 33 and 34 certain limited powers to correct the award, to make certain changes, and to give an additional award. Okay.
Got it, sir.
Yeah.
Right. I think this is all we had to cover for today, and I've already taken a lot more time than I had asked for.
Yeah.
Thank you so much for the bite, sir.
Yeah.
Thank
You're
you.
welcome. No, we keep in touch. Take care.
Right, sir. I'll definitely trouble you again.
Sure.
We can, sit for these mornings, maybe 10-15 minute bite on something important.
Just give a little advance notice. I'll plan my day and we can get along.
Lovely, sir. So nice of you. Thank you so much.
All the best. Continue your good job.
Thank you, sir.
Thing you're doing.
Thank you. Thank you so much.